Right now, there is an active rent increase petition in Calimesa, a capital improvement petition, and it will be reviewed by the hearing officer under the procedures established in Ordinance 410. That means I need to be careful not to comment on the merits of that case or say anything that could bias the process. But what I can do is explain how the ordinance functions because much of the public discussion has centered around misunderstandings. For example, some residents have said the petition should be denied simply because we can't afford it. And that is a heartfelt concern, and it absolutely deserves empathy. But under the law, affordability is not a legal basis for denial. The hearing officer is bound by the findings defined in Chapter 9.05, things like whether the work qualifies as a capital improvement, whether it benefits residents, whether the costs are verified, and whether the petition meets all procedural requirements. Those are the criteria that matter. The ordinance doesn't allow the city or the hearing officer to deny an otherwise valid petition solely because residents can't afford the increase. I know that can be difficult to hear, but it's part of maintaining a fair, consistent, and legally defensible system. Now, some residents may feel that this process only favors the park owner, but in reality, the thing that would favor the park owner the most would be not having a rent stabilization ordinance at all. The ordinance is what creates structure, limits, and accountability. Without it, rent increases would be left entirely to market forces with no review, no notice requirements, and no cap tied to inflation. So while the process may feel imperfect at times, it's precisely the system that provides protection, predictability, and fairness for everyone involved.